of the year, so don't get your hopes up. But I don't know whether you'll have a lot of fun in this class, but I will be having a lot of fun in this class. I was walking down here, or actually before I was walking down, I was like, I think I'll tell them just a little bit about my weekend. And it occurred to me like this is Wednesday for you all, so your weekend is 1,000 years ago. But I did want to show you. We took our daughter to her first game at Wrigley Field.
Oh, amazing.
And this is her at her first baseball game, her first Cubs game, not at Wrigley Field, 3 years ago. So she's gotten bigger, and I've gotten older and grayer and chubbier. So it was a good weekend, and I hope you had a good weekend as well. And there is a baseball connection to today. So if you don't like baseball, then learn to love America. No, just kidding. Just kidding. Okay, so we'll do housekeeping practice tip of the day. We're going to talk about reading statutes. We've been spending most of the semester in terms of reading stuff. We've been talking about reading precedents of the court. And most of your classes as a 1L are reading precedents about common law, but most of what lawyers do is read statutes. So we're going to spend 5 minutes on that. No, I'm just kidding. We'll spend more time on that. We'll read an actual statute and apply it to some facts, and then we'll read something that's analogous to a statute and apply that to some facts. And then we're going to talk about how to organize a memo. This will be an ongoing discussion throughout the rest of the semester pretty much. But we will kind of dip our toe in the water and look at it from a 30,000-foot perspective today, and we will do a very 5-minute practice, outlining, drafting of a memo in class. And then we will almost certainly have time for Garner games, and we'll also talk about the Garner reading that you did today. So housekeeping, first of all, Professor Giesel. Do any of you have Professor Giesel?
I don't.
A 1L class? Anyway, she's great. She's a very thoughtful person, and she's giving a talk today. I know, it seems like every class I have you all, I tell you about some talk. Don't feel like I'm pressuring you to go to these talks, but I just want you to be aware of it. I went to the talk she did last year, and I'm going to the one this year. And last year's was really, I learned a lot from last year's, and she's a good presenter. And this year's is, I think, a way more interesting topic than last year's. This year's topic is about, she speaks about legal ethics, and this year's topic was a case that the Supreme Court heard, and it was a capital defendant on trial for his life, and his attorney decided that he would tell the jury, that the defendant committed the murder. And I see some eyes. And the defendant wanted to maintain his innocence. And here was the attorney's calculation. There are 2 phases of a capital murder trial. There's the guilt phase, and then if you're convicted, there's the sentencing phase. In the sentencing phase, that attorney's job is to save your life, to get you life in prison rather than a death sentence. And it's like a whole other trial. And the attorney thought, I need to maintain credibility with this jury so that when I argue the sentencing phase, the jury will spare his life. And if I claim that he has some crazy alibi that is completely implausible at the guilt phase, then the jury will not go with me at the sentencing phase. So he pursued this strategy against the defendant's wishes. He ended up losing both phases. And the defendant, not surprisingly, sued for appealed on ineffective assistance of counsel because you had a constitutional right to an effective attorney. And so you'll find out from Professor Giesel who won. Really, I think it's an interesting case. It was a divided court and vigorous dissent. Good case. Okay. What?
When and where are you?
Oh yeah, thank you. 1210, and I don't know what room. There are only 3 rooms in this building that people do talks in.
I think it's in the console.
Oh, it is. So there are 4 rooms in this building that people do talks in, and there's a poster every corner. So when you walk out of here, read the first poster you see. It'll tell you what. You want to maybe Google or look at Daily Docket. I'm sure it's in the Daily Docket.
And if you don't, the Cox Lounge is it's like the faculty lounge, upstairs, like if you go up the fancy marble stairs, it's that room, cause I didn't know what it was.
Thanks.
That's where that is.
Yeah, 12:10. It's also pretty short. I think it ends at 12:50, so it's not like an hour and a half commitment or anything.
Will be served?
Yep.
Is lunch? Are they serving lunch?
Pizza.
So kind of. Okay, so we went over Judy Fisher 28 to 29 exercises in class already. But if you have questions, let me know. Like, come see me, and we'll go over your specific answers question by question. If there was something after class that you were like, oh, well, you told me the right answer for question 3, but I don't understand why. That's totally normal, and my door is open.
It's in 275.
275, so that kind of thing. 275, 12:10, and pizza. Thank goodness, Samantha, you know about
Thanks.
10 times
Daily
more things
don't.
than I do. Okay. Homework for next class, please read the Brian Garner sample memo. So if you look in your Brian Garner book, it's one of the appendix, appendix B. Nope, appendix, oh, well, it's appendix B. It starts on page 193. Appendix B, document 1. So don't feel like you have to memorize every word of this memo. The idea is for you to see an example of how a memo works. Our memo will be a little bit different. In particular, our memo will have a facts section. I can't believe this memo does not have a facts section, but we'll get to all of that later. But I think it's a useful example of a memo, and then I'm also going to email you another sample memo that's in a different style that I think is also instructive, and it's written by this professor named Gardner from another school, so I call it Gardner's sample memo. I email it to you. So we'll be prepared to talk about both of those memos in class, and then take a look at Brian Gardner section 21 for homework, and just first read it, and then you don't have to send me your answers to these questions, but think about these 3 questions. The principles that are explained in Gardner 21, does the Barger memo apply those principles, and does the Gardner memo apply those principles, and how? Okay, that's all housekeeping. Any housekeeping questions? Yeah.
What was that Barger sample memo again?
It was, I'm gonna email it to you.
Oh, sure.
It's shorter, it's not really more concise, it's just dealing with a simpler issue. And I'm sending them both to you so you can see some different styles. I'm open to different styles, but within limits. Like, I'll tell you where where you have discretion, I'll tell you where you don't have discretion. The Barger memo is an electronic document that has embedded notes. So if you have the capability of reading the embedded notes, be sure to do those. Be sure to read them because I think they're instructive. Okay, practice tip of the day is when you send an email, before you actually, if it's going to have an attachment, put the attachment before you actually write the email. Because the thing that trips me up is I'll write the email and then forget to send the attachment, I'll press send. So I had to send about 100 emails with an attachment this weekend. They all had basically the same text, but I was like sending them to 100 different people. And I followed this practice tip myself, so I've been blabbing about it for 4 years now. But I actually occasionally practice what I do. Okay. All right, so on to statutory law, but before that, a quick recap of common law, precedent, things that we've talked about. So, PREA, true or false? Common law is just another word that means the exact same thing as a precedent of the court. No, correct. Tell us what common law is.
It's from the old English law, right? And the precedent would just be like older cases that have been decided before from the court.
Yep. That's right. So a precedent is any case that's been decided by the court. And sometimes courts decide cases about common law, but sometimes they decide cases about statutory law or constitutional law. And so all of those are different kinds of precedents. So we have this box. This is all the precedents of, let's say, the Kentucky Supreme Court. And of those precedents, these are the common law precedents. These are the precedents about judge-made common law. And let's say these are the statutory law precedents where the court is interpreting a statute. And the rest of this is constitutional law. This is definitely not to scale because constitutional law would be a tiny part. Okay, so great job, Priya. And actually, Priya anticipated where I was going to go next, which was just a slight addition to what we've talked about before. I've been saying common law is judge-made law, which I think it is. It's kind of how it's understood today. There's no statutes. The judge has to figure out, well, like, who should own this property? Well, should it be the person who's lived there for 10 years or the person who has the deed? Well, I'm just going to, there's no statutes. I'm just going to make up what the rules should be. So it's common law, judge-made law. But the judge is supposed to be not just winging it based on what side of the bed she woke up on that day. The judge is supposed to be kind of looking to previous practice. And the phrase common law comes from England when the courts were the king's courts, and the king wanted all the stuff to be done in accordance with the king's will. And so, the king had this consistent common practice, and the courts kind of tried to figure out what that was and then apply it in a consistent way over time. So if you hear the term common law while you're in law school, well, where does it come from? It's supposed to be judges creating law based on what the tradition has been in the past. That tradition begins with the king. Okay, now that's common law. But as we said, many precedents have nothing to do with common law. Instead, many precedents are court decisions interpreting a statute that's been written by a legislature. So, how do we read that statute? Let's take a look. Where's Alex? Let's imagine you're not 3 weeks into law school. You're 0 weeks into law school. And someone says, hey, I'm wondering if I violated this law that's in a statute. And you're like, well, I don't know whether you violated the law. Let me check. What's the first thing, you know all the facts of their situation. What's the first thing you would do?
Do some research on the statute. Are you talking about
Yeah.
your jurisdiction?
Yeah, well, and what's the first step in your research to figure out what a statute means? It's really, it's like the Jeopardy category stupid answers. This is so obvious, there's a good chance you're gonna miss it just because it's such an obvious first step. But you're trying to figure out what a statute means, what's the first thing you do?
You're trying to figure out what it means. I mean, just look at the definition.
Yeah, or even before you read the statute. You look it up.
Yeah.
So the first step of your research is look up the statute and actually read the statute. And although this seems elementary, you would kind of be surprised. So let's see, we've done that. Okay. So you want to figure out what a statute means. You start with the text. And what do you look for? Alex was getting into this very, very wisely. One thing you want to look for is jurisdiction. So where does the statute apply? Bless you. If it's a Kentucky statute, likely it's going to apply in Kentucky. But if your events happen in Indiana, don't go look at a Kentucky statute. And then the heart of the text is going to be the elements of the statute. And elements just means what is the statute, what is illegal? According to the statute, what does it take for something to be illegal? And we'll look at an example of some elements. And then finally, the remedy, what are the consequences for breaking the law? Now, sometimes the statute won't lay out the remedy exactly, but sometimes it'll be right there in the statute. Okay. So, Alex, we've looked at the words. Obvious first step. We've now read the text of the statute. And let's imagine that there is still some ambiguity in the statute. Like it says don't litter, but you know, it's not totally obvious whether litter includes a banana peel or not. So, what's the next thing we should do?
Search for precedent.
Exactly, exactly. See how the text has been interpreted by courts. You can look for cases on Lexis. But you can also just go to the statutory text on Lexis, look at the annotations, and Lexis will often tell you lots of cases that have cited to that and interpreted that statute. So they've kind of done some of your research for you. And then another thing you can do is look at secondary sources for cases. So if there's a treatise on Kentucky law, you go to the section of that treatise that talks about littering, and that treatise has done a lot of your research for you. You look up all these cases. Oh yeah, there's a case from 2 years ago by the Kentucky Supreme Court saying that a banana peel does count as littering, so now I know how to interpret litter for the purposes of my client's problem. But what if there's not clear precedent? Then you use other tools of interpretation. So Alex also anticipated this very cleverly. You might look at the dictionary. You might look at the structure of the statute. Maybe the phrase litter clearly applies to banana peels somewhere else in the statute. So you might think, well, I'm going to use that to inform this. Look at the context. Maybe the statute was written at a time where there was an epidemic of banana peels being thrown on the ground. So you're like, oh wow, okay, they clearly wanted to like deal with this problem. That's the purpose behind the statute. Look at the purpose. And then if all else fails, you kind of ask yourself, well, what would make the world a better place? Do we want to live in a world where banana peels are on the ground? Maybe not. But on the other hand, do we want to live in a world where like, you know, you have to inconvenience somebody by making them go find a trash can every time they want to throw a banana peel? Maybe not. Your policy preferences are going to inform that. And that's why it really is a last resort, because ideally we don't want judges' personal preferences to be informing this question too much. But you will see, sometimes when all else fails, judges just say, well, I think the world will be better with no banana peels, so case closed. All right, so let's look at what this would actually, let's look at an actual statute. And if we look this up on Lexis, we would look up Virginia Code section 56. So the first thing we're going to look at is jurisdiction, Virginia. Okay, that's obvious enough. Now, big enough? We'll look at the elements of this statute. First we'll read the text, we'll break it into elements. This statute says, no cemetery shall be established within 250 yards of any residence without the consent of the owner of the legal title and equitable title of such residence. So let's just forget, for our purposes, the legal title, equitable title, all that stuff. Okay, just no cemetery shall be established within 250 yards of any residence without the consent of the owner of the residence. How many elements? I broke it down to 4. We could argue maybe it should be 5. Maybe we should treat 250 yards as one element and residence as another element. You have to prove it's a residence. But for our purposes, we'll break it down in these 4 elements. And then if you look this up, you would see the remedies are unstated. That usually suggests you can at least get an injunction. So if somebody's going to violate a statute, you can go to court, you can say, I want an injunction, which means I want the court to enjoin this other person from doing what this other person is going to do. So the correlation order says, you can't do that. That's an injunction. So let's imagine that you are an attorney. Oh no, before we do that, let's talk about the key terms of the statute. And then we'll apply it to the facts. Let's do a little bit of rule explanation here. So Zach, where's Zach?
Here.
What are some key terms? What are some terms here that you're like, okay, we better know what this means.
To be established.
Yep. What does it mean to establish? And actually, Zach has hit on the very key term that we will be interpreting when we apply this to facts. So, Joe, what else, Zach? You could almost pick any word in there because almost any word is going to be relevant. But
Define a residence.
yeah, what does a residence mean? Okay, so like clearly, my house is a residence. Probably Walmart is not a residence. But like my mom used to run a stationery shop. The landlord lived above the shop. Like had a little apartment or whatever above the shop. So was that building a residence or was that building commercial? So you know, we want to know what that means. What does consent mean? 250 yards is pretty easy to interpret. It's kind of like 35 years to be president. But even the obvious words can be important. So if you see
Cemetery.
what are you saying?
I say you could say, what is a cemetery? Like,
Exactly. What counts as a cemetery? We could maybe imagine some things that are not obviously cemeteries, but that might be. You know, if I bury my pet in my backyard, am I
Out
violating
front.
this law?
Yeah, out front.
Out front.
Brandeis.
Oh yeah, Brandeis. When they first told me Brandeis was literally out front, I thought my students were kidding. No way. But then I now think that anytime we name a building after someone, we should force them to be buried in front of the building. Right? It's not enough to just give us $1 million. You also have to give us your body. And we're gonna put it out front.
Then there'd be so many parts of George Washington.
That's true. That's true. That's fine. I'm Catholic. We do this with saints. Like you got one, like a fingernail over here and a leg over here, and relics all over the world. Look for and or. So actually, yeah. So I said ignore the legal and equitable thing, but look at the second line, last word and. When you're interpreting a statute, pay very close attention to whether the word and is used or whether the word or is used, because it can make the difference in terms of whether your client is going to win or lose. So imagine that your client has legal title, but not equitable title. Now, I'm not a property law person, so don't actually ask me what the difference is between legal title and equitable title. But I'm going to guess legal title is like a formal title and equitable is more of a functional control title. But in any event, let's imagine you have one, not the other. In this statute, you don't count as the owner. You have to have both, the legal title and equitable title. But if it said or, legal title or equitable title, and you only had one, well, then you count as the owner. So, and or make a big difference. All right. Now you're the attorney. Now the client comes in. Client says, I live in the city of Petersburg, Virginia, and I'm very upset with my city. It's planning to expand an existing cemetery into an area within 250 yards of my residence. So I want to sue. Michaela, where might ambiguity be?
Can you read it?
Yeah, no problem. I live in Petersburg, Virginia, and the city wants to expand an existing cemetery into an area that's within 250 yards of my residence. So right now there is a cemetery, and it's farther away than 250 yards from my house. But the city wants to expand that cemetery, and the expansion will now be within 250 yards of my house. And so I want to sue them and stop them. And I come to you as my attorney, and I'm like, do you think I have a clear winner? Do you think I have a clear loser? Or do you think that we better do some more research because just on the face of the statute, it's not obvious I'm going to win or lose?
I think the third option.
That's right. And why is
because
that?
the cemetery is already there.
Yep.
So technically it's already established. So you're just expanding it, so does it count?
That's right. And can you imagine an argument that it wouldn't count? Sounds like definitely. That's the argument you're hinting at. But can you imagine an argument that it would count?
Yeah.
Maybe. I mean, you know, if the point of this statute is to keep cemeteries 250 yards away from everybody's house, then, you know, this expansion would be frustrating the purpose of this statute. But if you remember going back to things we do first, we start with the text, and if the text is clear, game over. We look at precedent. If the precedent is clear, game over. We only get to the whether or not something is going to frustrate the purpose of the statute if there's remaining ambiguity. So you're exactly right, Michaela, that the key word, the key term for our purposes here is going to be, what does established mean? Is established narrow so that it does not include an expansion of an existing cemetery? Or is established broad enough that it would include expansion of an existing cemetery? So you would tell the attorney exactly what you would tell your client exactly what you told me. So you've got 3 years away from graduation, but you're already basically telling the client what you would want to be telling the clients. Good job. And then you would go do some research, or if you're at a big fancy law firm, then you would tell your junior associate to go do some research. And so the associate goes and looks at some cases and finds oh, we have to actually go on Lexis. Yeah. So I'll be the junior associate. Oh, it's like 2 o'clock in the morning. I'm so tired. Now I gotta do this other assignment. This partner ruined my weekend. Thanks for nothing, McKella. And I gotta wait for the internet to come on. That's annoying. So I'll go to Lexis and go to Lexis Advance. You all will be doing this in about a month, so prepare yourself. And I search around. Maybe I remember we said look at treatise. Maybe I go to the statute and look at the statute and look at the annotations at the bottom, and maybe that annotation says, hey, there's this case about a similar fact pattern. So I'm going to go read that case, and here's what the case is, 29 SE 2D 357. So I go look at this. Temple v. Petersburg. I know that this is not actually the case, but I might skim it to get an idea. And then I start reading this case. So, it was kind of small, but okay. So I start skimming it. The appellants, complainants, blah blah blah. This is a really bad way to start it, but they wanted to enjoin the city from using a tract of land. The plot adjoined, been established and used as a cemetery. So this is a cemetery that's been established and used for 100 years. But now the city wants to add an addition to the cemetery. So here's the statute. It's the same one that we were dealing with. Specifically, the controversy concerns the meaning to be given to the word established. Aha, that's our key term. So we're going to read on, and we're going to find out what they did, and we'll keep going. The elementary, that the ultimate aim of rules of interpretation is to ascertain the intention of the legislature, the enactment of the statute. Okay? So we're not just going to make up what we think the world will be better. We're going to actually try to figure out what the legislature did. Quaint notion of how to do law, but probably a strong one. If the legislature's intent is perfectly clear from the language or the rules of construction, like looking at the structure of the statute, then we go with that. We're not allowed to make it up on our own. If it's plain and ambiguous, we give it effect. Then we keep reading. The word established is defined in the dictionary, so we're going to look at some dictionary definitions. To originate and secure a permanent existence of, to found, to institute, to create and regulate. Okay, so the legislature in its wisdom, unclear if the court's being sarcastic there or not, but the legislature in its wisdom saw fit to prohibit the establishment of cemeteries, did not see fit to prohibit enlargements or addition. Well, that's useful for us to know. The language could not be plainer. I don't know if that's true, but whatever. I think that's a pretty easy answer here. From it, we can see with certainty that while a cemetery may not be established in a city or a town within 250 yards, blah, 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 it may be added to or enlarged without running counter to the inhibition found in section 56. So they go on, and they basically explain a little bit more. There's a difference between the word established and the word enlarged, just like McKella was suggesting there might be. From the foregoing language, legalese, terrible phrase, taken from section 53, completely demonstrates, exaggeration there, but the legislature did not intend the words establish and enlarge to be used interchangeably, but that the use of one excluded any idea that it embraced or meant the other. As used, they are mutually exclusive. To enlarge or add to a cemetery is not to establish one within the meaning of section 56. So what does that mean? No cemetery may be established within 250 yards, but you can expand an existing cemetery to within 250 yards. So, Michaela, what do you tell our client?
That he or she most likely doesn't have a case.
Yep, that's right. Too bad, so sad. Yeah.
I feel like if I was an attorney for someone who was trying to, put the cemetery up, who wanted to establish one and needed space, based on this, they could just put one there that is right up to the 250-yard mark, and then wait a week or any amount of time, as it say, and then expand it and completely get around this.
First of all, that's a great legal argument for why this decision was wrong. Like if you were arguing this, what's it called? Temple v. Peterson. So let's say you were the attorney in Temple v. Peterson trying to stop the expansion of the cemetery. I mean, that's a great argument that you should make to the court. You cannot rule for the city and the cemetery expansion in this case, because if you do, it will nullify the entire statute. It'll be so easy to just get around statute. So there's a strong argument there. And then also, let's flip it. Let's imagine that the city wants to do this expansion, and you are the attorney for the city, or no, sorry, city wants to establish a cemetery, and you're the attorney for the city. You've just given the city a nice roadmap. They come to you like, how can we do this? There's this statute that says we can't. We say, why don't you establish one that's not 250 yards? It's farther away than 250 yards, and then why don't you just expand it the next week? Now, if you were literally, if they were that transparent, I think a court would probably maybe distinguish Temple v. Peterson and say like, no, you can't. The city can't do it quite like that. But what if they established it 1 year and then expanded it the next year? So I'm definitely not saying that Temple v. Peterson was correctly decided, or that it was wrong, or that it was wrongly decided. I don't really care what Virginia does with its cemeteries. I don't have a horse in that race. But it's a great thought. Whether you're trying to prevent this decision from happening, or whether you're representing the city and trying to exploit this decision. Other questions or thoughts? Good. So I want to use my attorney. And Michaela too. Michaela was like, we're gonna go do the research. Yeah, don't just wing it. Okay, so let's do this again. And then I'm gonna talk about how to do a memo, and then you will write a memo based on this hypothetical that we're going to do. So I have some incentive beyond just the love of learning how to do statutory interpretation and application. Okay, so here's a quick trivia question. The rules of tennis are 17 pages long. Okay? 17 pages long. Where's Sydney? I didn't bring my map today, so I'm sorry, I'm still learning. Sydney, how long do you think the rules of baseball are? No reason you would know this, just take a guess, and then we're going to vote. Over, under. Just name a number. Rules of tennis are 17 pages. How long do you think rules of baseball are? 42. Okay. Who thinks that? Who'll take the over? Okay. Who'll take the under? All right, so the majority's with the under. The minority would win, because although the rules of tennis are only 17 pages long, the rules of baseball are 151 pages long. So I asked Samantha on the way down here, I said, like, how many people in the room not are familiar with all 151? I'm not, almost no one is familiar with all 151 pages, but how many people know the basic one-page version of how a baseball game works? Three. You don't have to raise your hand, because I don't want to put someone on the spot who doesn't. But there's three. Let's actually just, I think part of what an attorney does is explain something complex and simplify it, whether it's to the court or to a client or to a supervisor. Emily Lineweaver.
Oh gosh.
Who's a baseball fan? Okay, so I saw Emily's hand. Emily, explain in 30 seconds to someone from Mars how, or let's explain from a country that's never played baseball, no one knows baseball. Just explain the rules of baseball.
Alright, so you've got 9 players per team. You have infield, outfield. You have 4 bases, home, first, second, third. You have to hit the ball hard enough, but not to that you're not going one way. And then you have to run the bases as fast as you can. If someone catches the ball before it hits the ground, you're out, which means you have to go to the back of the line, try and hit again. You have to, if you make it around all 4 plates and make it from home back to home, you get a point for your team. Otherwise, there are no points. You have to deal with the fact that I've completely brain farted.
That's all right. It's probably about 30 seconds. So you covered a lot there. It's actually a really hard exercise.
Yeah, good
and you
job.
have to bear in mind the curse of knowledge here. That you know what the infield is, you know what the outfield is, you know what a base is, but your audience doesn't. In this hypothetical. So actually, in future years, maybe I'll actually have people take 5 minutes and try to write in a paragraph, just a 1-paragraph explanation of how baseball works.
Oh, that's easier.
Yeah, because you're not on the spot. But in any event, I think it's actually really hard. And actually, it would help to have a diagram too. So here's the text of the statute that we're going to look at in this 151 page long statute. We're going to look at a particular provision, and that provision is the infield fly rule. So what we would do is we would go to the official rules of baseball, and we would start by, this page 53 of the PDF.
Yeah, I said that and he has one of these. It's like that. That's why it's got to be a ton.
It's probably much more complicated. It's because not complicated, more rules.
They're just not showing up.
Yeah, there's more stuff going on. You know what you're paying for.
But maybe it's
There's different parts.
Maybe it's 41 of the top pages,
Yeah.
Like
353 is just too much.
Oh.
It's more simple. Like soccer.
Soccer, the rules of soccer would be tough. It'd probably take a couple of pages to explain offsides.
But anything with ping pong, tennis, just one-on-one sports like boxing, I think would be so short. Either maybe go to boxing.
What rule is it?
Huh? Yeah. I don't know if boxing would be short.
Have you ever boxed before?
A little bit. Have you?
No. I've been beat up a couple times.
Yeah. I went to this one Shake Shack down the street, like in the prison place. And there's a boxing coach. So it must be pretty big.
I had a dude, I don't know.
Yeah, exactly.
Okay. All right.
I kid.
Okay, so in baseball, you can become out any number of ways. A, B, C, D, E, F, G, H. So, for example, what's one of those ways? It becomes dead when.
That would be an out.
Yeah, why is that? Yeah, I guess so. Okay. But that's not out. I think the numbers.
That's a dead ball.
changed since last year. Okay.
We should try tennis next time.
509.
That's pages.
You know what? Okay. Screw that. Okay, we're just gonna do the excerpt of it. Okay. Trying to find the actual rule book, but so you go to the actual rule book and you read about what the infield fly rule is. An infield fly is a fair fly ball, not including a line drive or attempted bunt, which can be caught by an infielder with ordinary effort when first and second or first, second, and third bases are occupied before 2 are out. So imagine if you're an attorney and this is like what the statute says, you're going to try to break this into elements just like we broke the cemetery rule into elements. Before we do, we would look, there's a little explanation here, comment. On the infield fly rule, the umpire is to rule whether the ball could ordinarily have been handled by an infielder, not by some arbitrary limitation such as the grass or the baselines. The umpire must rule also that a ball is an infield fly, even if handled by an outfielder. If, in the umpire's judgment, the ball could have been as easily handled by an infielder. So, in case anyone doesn't know, here's a baseball diamond. Here's the outfield. This is again not to scale. Okay. The X's are the infielders. And then way out here, hundreds of feet away, are the outfielders. So the rule here is, and it's a foul ball if it's out of play here. It's a fair ball if it's within the field of play. Okay, an infield fly is a fair fly ball, which can be caught by an infielder with ordinary effort when first and second, so there's a runner on first and a runner on second, or there's a runner on first, a runner on second, and a runner on third are occupied. And 3 outs in an inning, they have to be, what does it say, before 2 are out. So there has to be either 0 out or 1 out. But if there's 2 out, this rule doesn't apply. Okay, so, Bailey, let's walk through what the elements of this rule are. So don't worry about the comment, just the rule itself. Remember with the cemetery, we broke it down into 4 parts, and in order to, for that statute to be applicable, just to recap, we had to show that we were dealing with a cemetery, it was being established, it was within 250 yards of residence, and it was without the consent of the owner of the residence. So, what are some elements of this statute?
It can be caught by an infielder with ordinary effort.
Yep. Can be caught by infielder with ordinary effort. Great.
And then one before that is, I guess so a fair fly ball.
Yep.
But it cannot include a line drive or an attempted bunt.
Okay, fair fly ball.
And then it can only happen when first and second or first, second, and third bases are occupied before 2 are out, which is a separate element.
There have to be runners on first and second, or first, second, and third.
And then before 2 are out.
And what'd you say?
Before 2 are out.
Before 2 are out. Perfect. Element 1, element 2, element 3, doesn't really matter what order we go in, and element 4. So, in order for the umpire to say infield fly, which has the effect, by the way, we should say this, has the effect of meaning that the batter is out and the runners have to stay at the bases where they were. That's the effect of an infield fly rule being invoked by the umpire. The batter is out, the runners stay where they are. And that's true even if the fielder does not catch the ball. So it's a ball that could be caught by an infielder with ordinary effort. The infield fly rule gets called by the umpire while the ball is still in the air. And then whether the fielder catches that ball or doesn't catch the ball, it doesn't matter. The play is already over. Okay? Now, that's a weird thing to happen. Normally players have to catch the ball. And the weird thing happens that only occurs when these 4 elements are met, just like the 4 elements of the cemetery rule. Fair fly ball, first and second base is occupied, then first, second, third base is occupied. For 4 2-outs and a pop and a fair fly ball that can be caught by an infielder with ordinary effort. Okay? So if we were doing rule explanation, we would break the rule down into these 4 elements, and most of these are pretty self-explanatory. What is a fair fly ball? You know, it's fair if it's within here. And the rule actually helps us know a fly ball excludes line drives, it excludes bunts. First and second base occupied, that's self-explanatory. 4 2-outs, that's extremely self-explanatory. Can be caught by an infielder with ordinary effort. There's gonna be some ambiguity there. Some room for judgment. Okay, so now let's imagine the client comes to you and says, I'm going to show you a video of my pop-up. And you can't really sue an umpire or appeal. You can't appeal to it. But I think I was wrong. I think I was wrong here. I think the umpire got this call wrong. So let me set up the video, and then you watch it as you would be an attorney watching and looking for the different elements. Okay? I'll set up the video. It's a Major League Baseball wild card playoff game from 2012. And what do we have here? There are runners on first and second. There's 1 out. And I'm just going to tell you right now, it's a fair fly ball. Okay? So, Elizabeth. Yes. Fair fly ball. Sorry. So I just, how many of the elements have I told you are already satisfied?
Can you read that again?
Yep, yep.
Okay.
So, playoff game, there are runners on, what did I say? First and second. Runners on first and second, so element 2 is satisfied. There's 1 out. Does that satisfy an element? Yep, satisfies element 3. It's before there are 2 outs. And it's a fair fly ball. Element 1 is satisfied. So as an attorney, when you look at this video, you're going to be thinking, okay, I know these 3 elements are satisfied. The only question is element 4 satisfied? Okay, so here's the
And we're looking for the person that hit the ball, right?
yeah, I'm imagining that you're the attorney for the person that hit the ball, but all your client has really asked you is like, was this an infield fly or not? So you just look.
If we're gonna define ordinary effort, someone like me who knows nothing about baseball, like would I have to bring in like an expert or something to define this is what that is?
Maybe. I mean, sometimes trials have expert witnesses, and one expert will say, I'm a baseball expert, and I say that the facts presented do not constitute an ordinary effort, and another expert will say they do constitute an ordinary effort, and then the jury decides. So the court explains the rule, the jury decides what facts actually happened. Although I will say, what the meaning of ordinary effort is, that is probably an interpretation the court would define, and then ask the jury whether or not the facts satisfy that. Okay. The 15-second ad, good grief. Can't skip it. Oh, gosh.
Oh, it's on fun.
Ah.
All right, so let's watch it again. Do it on full screen. And a note, first and second, only 1 out.
The context of the game.
It's going to be a fair fly ball, and what you're looking for as the attorney here
They're up 3.
is it something that can be caught by an infielder with ordinary effort.
Oh, it lands.
If you're a Bruins fan,
Let's watch it one more time, and I'm going to point out this time
Yeah.
who the infielder is. So baseball, you know, if you're a baseball fan, you know this already, but you do not have to be a baseball fan to succeed in this class. There's the ball, he pops it out. Okay, this guy right here
Shortstop.
is an infielder. Okay? This guy's also an infielder, but he's not going to be involved. Okay, so this guy's an infielder. This guy's an outfielder. Can it be caught by the infielder with ordinary effort?
Fly ball shallow left. Back is Cosma. He'll take it. He'll pop. Oh, it's gonna drop!
All right, so let's vote. Who thinks that this is an infield fly because it can be caught by the infielder with ordinary effort? One. Wow. So that's a heavy majority, super majority. Who thinks that it's not an infield fly? Okay, I think but anyway, I feel like I stacked the deck. Not stacked the deck, but led in a particular direction. But anyway, watch one more time. We'll see the result.
Simmons, fly ball shallow left. Back is Cosma. He'll take it. He'll pop. Oh, it's gonna drop! It falls. Miscommunication. And the bases are loaded and lost. This crowd's been crazy all night. I wonder if it affected their communication. They're calling it an infield fly rule. Wow. One umpire did. That's why Freddie Gonzalez is out.
As a Bruins fan, that's when you go for it.
This is a huge call here. You cannot call that. No way. He wasn't camped. That ball went up. And infield fly was called immediately. This is a game-changing decision. This is what happens.
I did not like that.
Okay, so even though the majority of you think it was an infield fly, and I lean toward thinking it's an infield fly, it never even occurred to the announcer that it was going to be an infield fly. I mean, that ball dropped. The announcer said the bases are now loaded, and then 20 seconds later, the announcer says to the audience, "Oh, they're calling it an infield fly." And so then he later says, like, there's no way that's an infield fly. And what are some of the things the announcer says in his interpretation of whether or not these elements are satisfied? He's obviously not like thinking of this in terms of elements, but he's like, you know, what do you say?
He wasn't camped?
He wasn't camped, so the infielder wasn't like in ready position to catch the ball. It was like camped right under it. And then he says one other thing that makes him think it's not an infield fly.
It was too deep.
It was too deep. The ball was too deep. But you know, note when we're just doing the text of the statute, camped and the depth of the pop fly are not express elements of this. Now, I think definitely the depth of the fly ball will inform whether or not it can be caught by an infielder, but it's not necessarily dispositive. And there's nothing about like whether or not the infielder did a good job of camping and putting himself in a position to catch it. The question is, could he have done a good job of getting in position to catch it with ordinary effort? So, you know, we're not going to watch all 5 minutes of this, but this is in Atlanta. The call goes against Atlanta. 1 second. And the Braves fans throw litter on the field for 19 minutes. Irate. And the Braves lose the game. The game was a game changer. I mean, you can't prove that causation is not the same as correlation. So you can't prove that it was because of this call. But the Braves were, had some momentum, bases loaded, down 3, only 1 out, and they don't make the comeback. So yeah, Elizabeth and then Phil.
Okay, like I get those are the elements of an infield fly rule, but what is an infield fly rule?
It is what the elements are.
A culmination.
What does it mean? Like,
So-
does he get out?
The person's out.
I guess what?
Oh, really?
Yeah, the
Yes.
guy that hit the ball's out.
Yeah.
Runners,
Hit it,
the
and it
runners
not
have
be
to
a
stay.
foul,
It's,
but
yes.
because of
The statutes.
It's to
That's
prevent.
what I said. I said this like 5 minutes ago.
You didn't say that he would get out. You didn't say the result.
He did.
He did.
Yes,
He
I
said
did.
even if he doesn't catch it. Yeah.
Thank you.
That's
Samantha says I said
I mean,
it.
I still don't get it, but you did say it.
Samantha is always right, and she says I said it. So.
That's true.
But in any event, that's the effect. And also, remember, I said there are like A through G ways to get out.
You can just let it.
Oh, and an infield fly is one of the ways to get out.
Okay.
It just doesn't make any sense.
Is that what both your questions were the same?
It was just like, yeah, I didn't hear what the result was.
So we remember it's a weird thing. Like you will be.
It is
out.
weird, yeah.
You'll be out even though they didn't catch your ball.
It's to prevent the infield from like intentionally dropping it and then.
Yeah, you want to zap, right?
Yeah.
I don't want to go too far in the weeds of like baseball because really I'm trying to make clear at every step that this is analogous to a statute and this is kind of the moves you will make as an attorney when interpreting a statute. But Zach was pointing out what the purpose of the rule is, which just for your curiosity, take 20 seconds, 30 seconds
Yeah.
and explain the purpose behind the rule.
It's just from preventing the like defense from intentionally dropping the ball and then getting like two of the runners out. Like if they drop the ball or like when the ball goes up, the runners aren't going to run because if they run, they can get thrown out. So they stay. And if the defense knows that and lets the ball hit the ground, they can get two of the runners out. So it's really to protect the offense.
Yes, it's a protection of the offense against kind of trickery by the defense, or rewarding the anyway. And there's actually a whole article about the infield fly rule. So if you go on Google and search,
Did you write
did I write it? I wish. It's been cited a lot more than any article I've written has been cited. So it's a classic. It's a classic article. But if you go on Google and search infield fly rule article, will be the first thing. Okay, so let's briefly go over how to organize a memo, and then I want you to write a memo. I mean, normally a memo will take like days to write, but I want you to just like outline in 5 minutes what a memo would be about this legal question. And just kind of see how things work. Okay? So. Not all memos are the same, but for the purposes of this class, your memo will have a heading. It will have a question presented. It will have a short answer. It will have a facts section. It will have a discussion section, which is really the meat of the memo. And we'll have a brief conclusion section. What is the purpose of this memo? Your supervisor at work wants to know the answer to some legal question. Maybe the legal question is, do you think our client will win? Maybe the legal question is, what is the meaning of caught by an infielder with ordinary effort? Maybe it's just about what is the meaning of established with regard to a cemetery. Maybe the legal question is, when this judge has heard cases about cigarette companies, how favorable has the judge been to cigarette companies? It could be any legal question. And so your memo is just an answer to that question, but you write it down so that it's kind of memorialized, and that way, you know, the person who's asking the question and getting the answer from you doesn't forget it as soon as you say it.
What is question? I can't read it.
Question presented.
Okay.
So we're going to read later a whole Garner section about what he calls the deep issue statement, which is his phrase for these first two short sections. Question presented, just think of it as, hey, reader, I'm going to tell you what the legal question is that this memo explores. Short answer, hey reader, I'm going to give you a very short answer. Legal question, does an expansion of an existing cemetery count as establishing a cemetery for the purposes of Virginia Code Section 56? Short answer, probably not, because, and a sentence or two about the because. I prefer, and Garner prefers, these to be a little on the long side. So 2 to 3 sentences for question presented, 2 to 3 sentences for short answer. That deep issue statement is kind of a discrete section. Then you treat the facts as its own discrete section. So you assume the reader knows nothing, including the reader you assume the reader doesn't know what you just said. In the facts section, you just explain the facts, not the law, just the facts. Here's what happened to our client. Here's what happened to the Braves. Right? They were down 3. There was 1 out, runner on first and second. There was a fly ball. It was pretty deep into left field. Shortstop came pretty close to getting under it, but wasn't totally set. There was a miscommunication. It dropped between shortstop and left fielder. Umpire called him out.
So none of the rule in that part.
You don't talk about the legal rules, but what do you do? You make sure that every legally relevant fact is mentioned.
Okay.
So you know the elements before you start writing your fact section. You don't explain all the elements, but you make sure that every fact that is going to be relevant to an element is mentioned in that fact section. Yeah.
I just had a question about the point that you made earlier about the intention of the statute writer, like the legislature. If the intention is what Zach said, that changes. I mean, that changes if I think that is a.
Yeah. So, good question. Let's look at our kind of order of interpretation. When there's ambiguity, so if it's clear text, we don't inquire very much into the purpose of the statute writer. But if it's not perfectly clear text, we see if there's a precedent that controls. If not, we look to the dictionary, structure, context, and if we get all the way to purpose, then we start thinking, okay, well, what was the kind of general goal of the statute? And let's interpret the statute in order to further that goal, not frustrate that goal. Make sense? Mm-hmm. Okay. But that wouldn't be in your facts section. Facts is just what happened in our case. That might be part of the discussion. Because in the discussion, the heart of the memo, we're going to get to all of this in much more depth another day. This is just kind of dipping our toe in the water. But a discussion will follow the CREAC structure. And what that means is you'll start with a conclusion. You'll then do rule explanation. You'll then do rule application. And you'll restate the conclusion. Now, don't be thrown off by technical terms. We've been talking about how to do this from day one. We did the Jeopardy exercises. We did the 35 years and what happens if you're 33. We did the litter. Rule explanation, you just explain the rule. The rule has 4 elements. The first 3 are pretty obvious. The 4th is a little bit more ambiguous. Let me tell you about how that ambiguity should be interpreted. In a general context, and here's the key, without talking about the facts of our case yet. You're just explaining the general rule. And so this rule explanation, you could copy and paste it into any memo about your statute. Then you get to rule application, and that's unique to our memo. It's unique to the facts of our particular client's case. So now that I've explained the rule, I'm going to apply this rule to these facts. And I'm going to tell you tell you the outcome. And that outcome, I previewed with this brief conclusion at the beginning, and I recap with this brief conclusion at the end.
Are those
The real key, and the pre and the review, the real key is explain the rule and then apply the rule. And then one more brief conclusion at the end. Yeah.
Okay, that was one of my questions, is if you did another conclusion after that conclusion.
You do, it kind of depends on how long the memo is. I mean, honestly, like, your first memo will be, I think, 2 to 3 pages long, 3 pages probably. And like, I want you to get some practice doing each of these sections, but in reality, like, you've now stated the conclusion about 14 times in about 3 pages. If your memo is 50 pages long, which it won't be for this class, but imagine a complex legal question, then it's really nice for that reader to have the conclusion section at the end, so if the reader wants to just skip right to that, the reader can get that.
Okay, and then I have one more question.
Yeah.
For like the rule explanation, if you were like citing like a precedent case or whatever, would that be where you?
Yep. And we will explore, like, we'll spend the whole day or more on rule explanation and the whole day more on rule application, we'll practice it. But just want you to see today kind of how we'll all fit together from a 30,000 foot level. Dimitri, did you?
I'm fine,
Okay.
thank you.
All right, so take 5 minutes, work with the person next to you, and obviously you're not going to write a memo in 5 minutes, but just kind of make some notes under each of these headings on what substance you would want to include there. And then we'll briefly talk, and then we'll do a garden game.
We're doing this about the end of the flag.
Just doing it like in 5 minutes.
About the end of the flag.
Oh, sorry. Yeah. The supervisor has come to you and has said that the umpire called an infield fly in the 8th inning of the Cardinal Braves 2012 wildcard game. Was the call correct? That's what your memo is about. Was the call correct?
Alright, so we gotta go. We gotta do this like format. Okay.
Oh, we're gonna have a pretty similar. Okay. And part of how you organize will depend on how long the memo is. So if your discussion section is going to be 20 pages long, and you're dealing with a rule that has 4 elements, and each of those elements has some complexity to it, you probably want to break that discussion section into 4 subsections, and for each element, do CREAC, where you explain that particular element, and then you apply that particular element to the facts of your case. So you would do 4 mini CREACs. For something that's as straightforward as this, at least for the first 3 elements, you could make a case that you don't want to break it into 4 subsections because this rule explanation is going to be a sentence. This rule application is just going to be a sentence. Same here, same here. And really the heart is right here. And so in any event, how would we do this? Well, first we would have, yeah.
Sorry, quick question. Do you think it would be helpful to do, or would you prefer to see like subheadings for each of those rules or elements that we want to explain further?
Yeah, again, it depends on the complexity,
right.
But if the more complex, the more reason there is for subheadings. I'm a pretty big subheadings fan. So if you look at the headings on page 193 of Garner, not these headings, but just the general heading on the top, you'll see that the memo should say who the memo is to, who the memo is from, that's you, the date, and the matter that it's regarding. So here you could imagine, to supervisor, from Phil, date August 29th, 2018, regarding Braves Cardinals infield fly. then the question presented, I could imagine 3 very short sentences. Maybe one's not so short, but an infield fly is when a fair fly ball can be caught by an infielder with ordinary effort, and there are runners on first and second, or first, second, and third before there are 2 outs. You kind of like summarize, make a little more concise the rule, but in general, in one sentence saying like, here's the rule. Here's what an infield fly is. Imagine a second sentence being something like, in our game, a ball, a fly ball went almost to the left fielder, but was high enough the shortstop was almost under it. Something like that. Just describe the play in one sentence. And then last sentence, the question, was this an infield fly? So one sentence about the rule, one sentence about the facts, and then a question, basically, do the facts satisfy the rule? And then short answer, if you're the majority that thought it was an infield fly, you could say yes, because you give a sentence or 2 explanation for why you think the answer is yes. I think a better answer would be probably yes. Because when you write a legal memo, you're not arguing to a court, you're not like trying to persuade a court to take your position. You're trying to tell your supervisor, okay, like, what is the law? And you do want to persuade them that you are right about your understanding of the law and its application to our facts. But you also want to convey to them that there may be some ambiguity. This is not a clear winner. I'll talk more about that later. But I just think the answer here, probably yes, because, and then explain why. I do the facts section, and here is a narrative. And you would probably just go in chronological order, like what happened. And so, Logan, where's Logan? Give me 1 or 2 facts that should be in your facts section.
There's runners present on first and second base. The ball that was hit is not a line drive or a bunt, but it was a pop fly that wasn't fair. That was fair.
Yep, good. Any other fact come to mind you should probably put in there?
But there's only 1 out.
Yeah, that's good. You want to make sure all the legally relevant facts are in there. And then we did the discussion. Rule explanation, tell me, Taylor, here's Taylor. How would you explain the infield fly rule? And you don't have to reinvent the wheel to do this explanation.
All 4 of those elements need to be present to constitute an infield fly.
Yep. And in terms of explaining those 4 elements, would you spend a lot of time explaining element 3? No. Everybody with a passing familiarity with baseball knows what it means to have fewer than 2 outs. Would you spend more time explaining element 4?
Yes.
Yeah. There's more room for ambiguity. Not everyone is going to always agree on what it means that a ball can be caught by an infielder with ordinary effort. So you kind of explain that, and what have we learned today might inform that explanation. What that's a question. What might inform that explanation? If this were a real case, what things would you look to? Hint, hint.
The video.
Well, that's for the facts of our case. But in terms of trying to explain the rule itself, I know it's kind of confusing because I'm flipping back and forth between the baseball rule and an actual statute. But imagine this were a statute. You would look to precedents of the court that have applied that statute before. That might help us explain the statute, explain the rule. Maybe a dictionary, the structure of the statute, context, purpose, all of these tools of interpretation. But at the top of that list, the text of the statute and court precedents that have clarified it. Because those are the things that this court is going to be especially bound by. And then you would apply this rule that you've just explained to our facts. So you would say all 4 elements are satisfied, and you would kind of go step by step. The first element is satisfied because it was a fair fly ball. Second element is satisfied. The 4th element is probably satisfied because, and then you would kind of explain what about our fly ball shows that it could have been caught by an infielder with ordinary effort. And ideally, there'll be some precedents out there, and you can say, hey, 5 years ago, there was a ball that the court said could be caught by an infielder with ordinary effort. And that ball 5 years ago is a lot like ours. That's the move that you will make all year in this class and as attorneys. Something from 5 years ago, that result was the result that we want, and you explain to your reader why our facts are like those facts. So 2007, there was this playoff game, and it was the Reds versus the Cubs, and it was a ball that was exact same amount of feet from home plate, and the umpire called that a infield fly, and a high court affirmed that, and so now ours just like that. Move. We do the same thing with the cemetery. You know, hey, there was this case, Petersburg v. Temple, and Temple v. Petersburg, and it dealt with almost the exact same facts as our case, and the city won that, and so therefore the city is going to win ours. And then you just summarize. Conclusion. This purpose of this, dipping our toe in the water, is not to explain everything or even 90% of things. It's just to show you kind of what something will look like at the end. It's kind of like an idea, a hint of what it will look like at the end. And then we're going to go next class, 1 step. Next class, 2 steps. We'll explore a deep issue statement. We'll explore rule explanation, and you'll practice a deep issue statement. You'll practice rule explanation. You'll practice rule application. We'll explore a facts section. We'll put it all together. It's to be great. It's to be great. So we have 9 minutes, kind of the extra 5 for our canceled class. Let's do one Garner game, and let's do it on active passive voice. But before we do the game, Jacob. Yeah. What are some of the reasons why, as a general matter, the active voice is preferable to the passive voice? There are exceptions. Sometimes you're going to want to use passive, but as a general matter, why is the active voice preferable to the passive voice?
It requires fewer words.
Yep.
It's more assertive.
Yep. So fewer words, more assertive, more lively. It often better reflects the chronology of what happens. So Jack threw the ball. There's this guy Jack, and then he threw the ball, whereas the ball was thrown by Jack out of chronology there. And then it meets the speaker's default expectation. So we've talked a little bit before about putting yourself in the reader's shoes, and the mind is just kind of used to the subject of the sentence performing some action on the object. And when you flip that, the ball was thrown by Jack, it just doesn't always meet the reader's expectation. So let's practice this. Take a look at basic number 1.
I can pull my book up. Man, I'm being lazy.
Plaintiff and 3 witnesses testified on behalf of the defendant.
Why would the plaintiff testify on behalf of
The plaintiff heard testimony.
No, man, after the plaintiff testified. After the plaintiff, 3 witnesses testified on behalf of the defendant.
Oh, I see what you're saying.
You know what I'm saying?
Yeah, let me see.
It's 2 separate
The
testimonies.
plaintiff and 3 witnesses on behalf of the defendant testified.
Yes.
I got you.
Okay. Testimony was heard from the plaintiff and from 3 witnesses
Just erase
on
the
behalf
apostrophe.
of the defendant, Shelby Boyd. Tell me why is this passive voice? What in this sentence is passive voice?
The was heard.
Yep.
Was heard is passive. The book gives the specific, like a rule that if you have a being followed by another verb, then it makes it passive.
And in particular, it's passive here because who did the hearing? Oh, the plaintiff. And, I see, yes, exactly. Yeah, the court did, which is another thing that's bad about the passive voice. Sometimes it obscures who the actual subject of the sentence is. So yes, the court did the hearing, and what did they hear? They heard the testimony. So passive voice, because you have the subject of the sentence, is not actually doing the hearing. Okay? So let's take a look at one way, not necessarily the best way. After the plaintiff testified, 3 witnesses testified in corporation. So this really kind of got creative and rewrote the sentence, but did rewrite it in an active voice and made it more concise and made it punchier. And if you look at what are the benefits of the active voice, fewer words, reflects chronology, meets speaker's default expectation, maybe not, and more lively. Yeah, I mean, it's more like the witnesses are doing the testifying. The witnesses there are doing the action. So after the plaintiff, 3 witnesses testified on the defendant's behalf. I think very strong there. Plaintiffs and 3 witnesses gave testimony on behalf of the defendant. That does put it in the active voice. Plaintiff and 3 witnesses heard testimony. So this is, they didn't actually hear the testimony. It's the court that heard their testimony. So that's it. So which number was this? Group 2. Which number was this?
4.
6. Which number wins? 6. The evens want to vote. Odds want to vote. Who wins? Who votes for? I was like, no way. Group 2 is the worst. Yeah, 50 points to Group 6. I'll see you Friday.
Dude, he's fine. Definitely like what you did, bro. Take it. Oh, I see what they did.